Good morning, friends. Welcome back to my channel, Advocate Jayashree's Musings on Law. Many people are of the doubt as to when we file a family case for divorce, matrimonial dispute, is the years of separation taken into account or is it the years of marriage? That is the number of years of separation or number of years of marriage. This is a common doubt which is prevalent. Today let us address this. Number of years of separation as well as the number of years of marriage both matter when it comes to divorce. For example, in Hindu law, up to a period of 1 year of marriage, that is, suppose that a marriage has happened today, 5th September 2025. Divorce cannot be filed under the Hindu Marriage Act for a period of 1 year. That is, still 6th September 2026. Even the next day it can be filed, but not within a period of 1 year of marriage unless until there are certain criteria which are met according to law, which says that a marriage can be declared as null and void within a period of 1 month, or which can be, it cannot be treated as a divorce, but it has the same effect as a divorce. The marriage is taken to be null and void. So in certain circumstances where there has been, for example, a fraud which has been committed by either spouse, either the husband or the wife or their families, families in the sense the husband or wife, or there is a terminal illness, either spouse is suffering from terminal illness which was not disclosed at the time of marriage. Even fraud which has not been disclosed at the time of marriage. If either spouse knew about the other spouse, say the play of fraud or the terminal illness before marriage, then the marriage cannot be termed as null and void. Divorce cannot be granted. Okay. So these are two things, and of course we have the sapinda, that is sagotra, same gotra, or they come under the same umbrella of ancestors. Then also the marriage can be declared as null and void. But of course this is not necessary that it should be known before marriage. Even if the person, either spouse, gets to know after marriage, the divorce can be granted, or the marriage can be declared as null and void, or any other ground like impotency, or right from the beginning of marriage there has been no communication at all between the husband and wife. They have not at all cohabited. Say for example, either the wife or the husband, they just get married in the mandap and then they leave. They don't come to the matrimonial home or stay with the wife or the husband, either spouse. So in that case, the entire 1 year has gone by without any communication, without knowing about the whereabouts. There are so many such criteria. So in such cases, marriage can be declared null and void, or divorce can be granted within the period of 1 year of marriage, but it should be proved. It cannot just be something which is like, I just say by word of mouth that this is what has happened. No. Everything, all the grounds, that is the reasons that I have mentioned, has to be proved by the spouse who is asking for the marriage to be declared as null and void or divorce. Okay, so this is the criteria. So number of years of marriage essential under the Hindu Marriage Act is 1 year before filing for divorce. Number of years of separation or number of months of separation can differ. That is not a problem, but the grounds for the marriage should be, the grounds of the divorce should be ably proved. It should be proved sufficiently. Same way when we go to the Christian Marriage Act, it is said that 2.5 years should lapse before filing for divorce. So this is coming under the Indian Divorce Act. Of course, the Christian way of their marriage act, the Christian Marriage Act, I won't say their, mine and all that, but the Christian Marriage Act says it should be 2.5 years before divorce can be filed. So that is also a very good option. So, as under the Special Marriage Act, of course, it depends. 1 year is the criteria. Again, we can go by anything because it is a marriage between two religions, right? People of two religions. So we have to see which religion, the personal law of which religion will take effect. So this is something which I have been receiving the query over and over again because many people are confused. Because some people say it is the years of separation which is important. There should be at least 1 year of separation. It is not 1 year of separation. Hindu Marriage Act, 1 year of marriage. Christian Marriage Act, 2.5 years of marriage. Unless, of course, on the other reasons which I have mentioned, divorce or treating the marriage as null and void can be taken to the court. I hope this has sufficiently cleared the doubts. Thank you.